The Department of Labor will soon promulgate regulations and different sorts of details based on sectors, etc., around quotas. And these quotas in employment can be based on race, sex, and disability. The date for promulgation is the end of March of this year. Business group Sakeliga has highlighted these issues repeatedly throughout the amendment to things like the Employment Equity Act. What are some of the permutations? How are things shaking out, etc., etc. So joining me to discuss this particular issue, some of the context, and of course, the major risks for employers in South Africa, those who need to generate economic activity and employ South African citizens, is Piet le Roux. Piet le Roux, of course, representing Sakeliga. Piet, thanks very much for your time with us here, back on the CRA channel. I think we spoke last year at some point, so it's good that we've got you back here early in February of 2025. So Piet, just a little bit of background to get from you. So as I mentioned, flowing out of the Employment Equity Act, this is where these quotas, these targets are coming from. I don't think we should use those words, things like targets and those measurements. I feel like it dilutes the actual implication of what these are, which are quotas. So just initially give us a bit of background on the Employment Equity Act and specifically these employment quotas.
Yes, this Employment Equity Amendment Act was loading for several years. When at last in 2023, it passed and was signed by President Cyril Ramaphosa. And the big change in the Employment Equity Act now versus what it was before is that now the minister can supposedly tell businesses what the composition of their workforce should be based on race, sex, and disability, even other demographic characteristics, and not only in general, but even specifically at every workplace, at every various levels within the company, and depending on where it is in the country. So we're really entering a maze of racial prescriptions to what hiring should look like. And it's not a target as the minister and the act would like us to believe. It's a quota, because if you don't meet these quotas, you're up for significant penalties, and you will not be allowed to do any transactions with the state. So this is a major change, whereas before you could circumvent it, or it could be you could define your own targets. You could be held to your own targets, but nevertheless you still define the targets. Now you're going to have the minister somewhere informed by the great insights from Luthuli House and the Union Building telling you what the racial and sex and the disability composition of your workforce must be within the next 5 years, or face significant penalties.
And Pete, do these regulations, as it were, go as far down as, for example, saying in a section in the Gauteng province, in the metro of Tshwane, in the barbershop industry, for example? Does the legislation open up that much space that the minister, or maybe someone that the minister appoints, could then, for example, set these quotas?
Well, it's a little bit like seeing like a state. So all states, by their nature, try and categorize and classify society based on what is legible to them. And in this case, the minister, based on the good work of his very interventionist and central planning predecessors like Minister Ibrahim Patel, is classifying the economy into different sectors. And now, in order to make these quotas more palatable, make them look more scientific, these sectors will get different quotas, each of them. And then supposedly all companies will fall neatly into one of these dozens of sectors, and then they will have to comply with the quotas in that sector. And then that sector will have, at least from what, as we can determine from the current draft regulations, will have several provinces, and the provinces will each have their own breakdown. And eventually all of this is supposed to magically roll up into a situation where every company in the country reflects the economically active population, or you can say the racial, sex, and disability characteristics of the country as a whole. So it's very much making every organic entity in society an image of the state. And interestingly, not only all South African companies, but also all international companies with a workplace in South Africa. And this is sure to count as a very subtle diplomacy in our times, with all the attention from the Trump administration currently on South Africa.
It's probably not going to help former President Mbeki, who has described a 180-degree turn in Washington, but completely taking out the context of what the South African government, I think, has done before the last year or so, and before the latest inauguration of President Trump, really not taking into context the domestic policy and legislative choices that the South African government has made that would bring South Africa to that sort of attention. But that's a sort of separate topic for another day. I think it's just important to mention for the former president. Piet, so you talked a bit about that international businesses would also be subjected to these, and just in terms of domestic companies that might be exempt, is there any threshold in terms of which businesses of which size this would apply? Is it based on number of employees, turnover maybe?
Yeah, so this is another change between the two acts, before and after amendment. Before, either companies above 50 employees or 50 or more, or above a certain turnover threshold, had to comply with certain sections of the Employment Equity Act. And now the Act's racial prescriptions and demographic prescriptions have become much more stringent, but the turnover threshold has been relaxed. So now it's just a blanket requirement for all companies with 50 or more employees. They will need to comply. You know, they would need to. They are supposedly. They supposedly need to comply with these regulations. Now, you may say, okay, so only big companies are affected. Actually, not many smaller companies have 50 or more employees. And additionally, this is an arbitrary number. It's really just a way to phase this into society. By way of comparison, a country like Namibia, which often mirrors the policy and legislative developments in South Africa, about 18 months, 2 years ago, they lowered their threshold to 10 employees. So really, there's no respite here, and we'll get to what we think as Sakeliga businesses should do, what the reaction should be. But let there be no mistake, this is a very, very interventionist attack on business, on the freedom to operate your own company, on the freedom to serve society, to make your own management and hiring decisions. This is something that cannot be accepted.
Pete, just in terms of enforcement, as it were, I feel, again, that's a very clinical way of putting it. But for companies that, quote unquote, don't comply with these new rules and regulations, you did touch on it a little bit. I just wanted to make sure we cover all the details. So on paper, the state could impose fines of up to 10% of turnover. Are there other enforcement mechanisms, as it were?
There are some exemptions supposedly in the regulations. In the some of the PowerPoint, the slide decks we saw shared in this current consultation period, which is a farce, but in this consultation period, some slide decks were shared. And in these slide decks, there are several grounds listed that can earn you some kind of exemption, but it's not clear by what mechanism you will be exempted, under what criteria. You know, will it be the clerk behind the desk on a Thursday, and if breakfast wasn't nice, you get the exemption or not? So this opens another whole door to corruption. But basically, this whole complex structure, of course, as all government regulations, makes some kind of room for exception, but it turns the default of society right on its head. The default in society, in a free society, in a prosperous society, is that you should have the freedom to do what is good for yourself and the people around you. And the government's now turning that around, and it says you are allowed to participate in the economy after you've complied with our prescriptions, and you can apply for an exemption. But otherwise, we're going to nail you.
And Pete, just in terms of coming to the end of our discussion here, looking at things going forward. So correct me if I'm wrong, but we're looking at the end of March. If there is a specific date, maybe the 31st of March. Maybe it's an April Fool's joke. They should have said this is the 1st of April, but unfortunately, I don't think that's the case. So just in terms of timelines, give us an idea. And then secondly, work that Sakeliga is undertaking and where you would advise businesses and individual citizens to get in touch with you and perhaps support some of that work.
Yes, so this is indeed a serious matter. Government is serious about rolling out the Employment Equity Amendment Act. So as much as it's delayed, as much as it happens haphazardly, as much as there are gaps and gaps that we will exploit in litigation, and the government is serious about rolling out the Employment Equity Amendment Act and these regulations. The current version is the third draft of regulations. We've been successful together with others in getting them to abandon the previous two drafts of regulations. So already some progress there and delays what we managed to achieve. But maybe this third time, lucky for them, they'll get the regulations out. And according to them, this will be by end of March. But fortunately, there is this wonderful phenomena in South Africa called state failure. And it's meant that many harmful policies actually only happen much further down the line than actually announced initially. I mean, just think of the NHI, just think of a lot of things. Thankfully, government's not very good at implementation, even the harmful policies. So we'll see if end of March deadline is actually met. It's their own late deadline. But then there is supposedly a 5-year period in which there should be progressive compliance with these quotas. And somewhere during that period, there will be increasing attempts at enforcement, and the department even announced last year and is actually in a hiring effort to employ more inspectors. So the department is trying to ramp up its enforcement mechanisms, but there are thousands and thousands of companies across this country, and we suspect that the government and the department is vastly underestimating the complexity of what they're asking to do, what they are pretending to be able to police. And they are also misjudging themselves in the very possibility of what they're trying to do. The quotas they prescribe are, as a matter of physical, of the laws of physics, not possible to comply with. It's inevitable that in many of these cases, the number of qualified people within these categories with the necessary experience and willing to work in a certain province at a certain time for a certain company, at a certain workplace, at a certain employment level, for a certain salary is just not going to match up. So there is lots of reasons to suspect that government is actually not going to be able to enforce this. I mean, think of e-tolls. That was fairly simple. You just supposedly drive through the toll gate and then you get an account, and you're not going to get your license if you don't pay. That was a sort of supposedly simple enforcement line. This Employment Equity Amendment Act is very complex, and we've spoken to great organizations like NIASA, the National Employers Association of South Africa. They specialize in advising employers on how to deal with these requirements and how to treat them, and not to try and pre-comply, but to do what is actually we call maximum appropriate non-compliance. So now we're getting to the last part of your question, which was how do we see the way forward? The first is this word of maximum appropriate non-compliance, or man up, if you wish. It is impossible to comply with these requirements. It is immoral to comply with these requirements, and you are likely exposing yourself to legal risks if you're an international company back in your home jurisdiction. And in South Africa, you're exposing yourself to litigation by the people who you are now required to classify by race and to actively discriminate on. You know, you need to prejudice one person in order to advance another under these regulations. So you're exposing yourself to lots of legal risks there, and we advise get in touch with an entity like NIASA to help you through that and do maximum appropriate non-compliance. But then on Sakeliga's side, we're ready to litigate against this at an appropriate juncture. That's probably after the regulations are promulgated. So we've been developing a litigation, we've been preparing, so we will litigate. Second thing is we will encourage people to do what we call maximum appropriate non-compliance. If you have to, of course, it's like anything the state does. If you absolutely have to, because otherwise the penalties are just too much, then, well, I guess weigh it up and do it. But if you can avoid it, certainly be judicious in and don't try and pre-comply or over-comply, because there are lots of problems with this. And then when do we intend to stop this? Well, we intend to stop our efforts either once the Act is of zero effect or once the Act is officially rolled back. This has to be done in order to secure a flourishing economy. And it's not easy because it's a state, it's a powerful actor in society. What it says has some authority, but unfortunately, by making these kinds of impossible laws to comply with, they are putting so many employers across the country in the same situation all at once, that you are no longer the exception. If you do the least possible compliance, you become the norm. And so, whereas before non-compliance was the exception, increasingly non-compliance and appropriate non-compliance, or the least possible compliance, will become the norm. Once a law asks the impossible, then we all end up being non-compliant, and then it just debases the whole idea of law itself.
There's another in a litany of examples that South Africa pursues in the context of low economic growth. Between 2013 and 2023, we averaged 0.8% GDP growth. And when you ask, well, why have we run out of money? Why are unemployment rates so high? This is one of those classic examples in the South African story of what government shouldn't be doing or shouldn't even try to be doing. But Piet, thanks very much for unpacking this matter for us. Organizations such as Sakeliga are vitally important for South Africa's civil society, for future prosperity, for citizens in this country to prosper over the long term. So thank you for the work that you do. And to those of you watching, if you want any more information, we will link to Sakeliga's latest press release below. Please go to their website and find out more, either in your private capacity or for your business going forward. You need all the information available to make the right decisions. That's also the role that we play here at the CRA. Thanks very much for watching. Until next time, this has been Chris Hattingh for the Centre for Risk Analysis. Take care.